Today on NBR's Toil and Trouble slot, I'm talking to Senior Associate in the Employment Law Team at LegalVision, Gerard Elwell. And Gerard, let's start talking about a few cases that show it's not all one-way traffic when it comes to employers suing each other.
Yes, thanks, Dita. There's a bit of a myth that only employees can sue employers, and generally we hear about those cases that come through the Employment Relations Authority and sometimes the Employment Court. But in limited circumstances, there is an opportunity for employers to sue employees. Now, that is quite narrow, and there's not a lot of cases that have gone all the way to the ERA or the Employment Court on that. Most employer claims settle prior, and so we don't hear about them. But there have been a couple of cases. So it usually relates to a breach of duties, so some fundamental duties of good faith and fidelity and confidentiality that the employee has to the employer that has cost them.
Right. So you've pulled out two quite interesting cases here. One is Rooney Earth Moving versus McTague and Oars. What was that all about?
Yes, so this was as you can imagine, a earth-moving company and suing their employee. They obtained a total of $4,300 in damages, and that was against former employees who had used their position to unlawfully solicit customers. And that was to entice them away from their employer to their business. So
Right.
It was effectively quite a serious breach of fidelity, loyalty to their employer, and the employer took action and they were successful in getting some damages, not a huge amount, but getting some damages there.
It kind of suggests Utu was a big part of it because that level of damages is almost negligible, isn't it, really? It's more like, how dare you, and it's kind of almost being hurt or distraught at the idea that an employee would take your business away.
Very much. And as I said, I get to see quite a lot of these cases, but they usually settle in mediation or confidentially, so they don't make any reports, so we can't speak about the specifics and people aren't aware of them. But often, and sometimes surprisingly, the employer is actually very hurt by a process where something's gone wrong in the employment relationship. So as well as the employee raising a personal grievance, quite often the employer asks me, well, can we raise one? What can we do? We were aggrieved. We've been hurt. Someone hasn't done what they said they would do. They've been dishonest. They've taken our customers or they've caused us loss. How can we sue them? So it's actually quite a common question that comes up. And my answer is probably a typical lawyer's answer of it depends.
It depends, yes. Now, the second case is Phoenix Cabs versus Artho. What's that all about?
Yes. So a taxi driver who was ordered to pay their employer $10,000, so quite a larger award, and that was the replacement cost for a vehicle. So they were a taxi driver, and they basically wrote off the vehicle whilst drunk. And I know quite an extreme example, but the ERA found that she was negligent in her duties, and as you can imagine, and she was ordered to also pay some additional costs there. Right. But it's an example where if there is a sort of a flagrant breach of your duties to your employer, that you may be held liable for that. In the normal course of your work, if you are behaving honestly and reasonably conscientiously and you make a mistake and it costs the business money, that's not normally recoverable. So, for example, you might remember not that long ago, some service station owners were deducting money for driveaways from their staff, and so that was quite unreasonable and probably illegal in terms of the employment law sphere, and that was quite unreasonable behaviour. So they couldn't really control that outcome, so they couldn't be held. But the couple of cases we've looked at have been either deliberate breaches or gross negligence. Getting drunk and riding off a car sort of is probably right up there in terms of damage that can be done.
Yes.
Yeah.
What happens when the employee says, I can't afford to pay you?
Yes, so that is an issue, and it goes both ways as well in terms of affordability. So that would depend on any settlement negotiations that were made. So one aspect is getting the decision, and then, as most lawyers know, the next aspect is enforcing it.
Yes.
And there's a variety of remedies available depending on the motivation and the resources of the employer or employee, depending on who got the award, that can be taking action against the company. So that can be initiating either bankruptcy proceedings against an individual or liquidation proceedings, winding up proceedings against a company. So, but that is quite time-consuming and quite costly. So when you do get an award, when we're acting for clients, we always hope that the other side is able and willing to pay,
Yes.
or feel that they must pay. Otherwise, it can drag things out a little bit.
Yeah, I can imagine. Now, we've heard this week from a few other sources that demand for whistleblower advice has shot up. Now, why has, first of all, maybe just background this change to the Whistleblower Act, if you can.
Yeah, so I think most people may have heard of the term whistleblowing, and that's what the statute, which is the Protected Disclosures Act, that's what the statutes sort of become known as, and more commonly known as. So our idea, or the idea that sort of evokes, is that someone sees something terrible happening in their workplace and they want to report it. And how do they go about that? So we have had legislation for more than 20 years. The first legislation was passed in 2000, and that was quite world-leading in a way. There weren't many other countries that had any legislation around whistleblowing. And so in theory it looked quite good, and the framework was there for people to be able to report what they thought was wrongdoing and then be protected. So one of the fears, obviously, is if you report something that it will have consequences on your employment, and that's especially exaggerated if the person you're reporting on is more senior to you in the management level. And we have had cases prior. There was the Ministry of Transport case where there was ongoing fraud, and that was reported.
Yes.
And yet the person who made the report actually ended up suffering quite considerably as a result of retaliation. So the purpose of the legislation is to allow people a process for reporting serious wrongdoing. So it's not any minor thing. It's in a category that's defined as serious wrongdoing, and that's usually a criminal offence, obstruction of justice, any sort of fraud or corruption, and also any risk to health and safety.
So, okay, that's what's changed. Now, why are employers now needing much more advice about it?
It's been broadened, the scope of it. So it generally, when it was brought in, it applied mostly to public sector organisations, and concern, I guess, behind the scenes was concern around corruption, and that New Zealand needs to continue to be seen as relatively free from corrupt and a good place to do business, where people can trust the process, whereas to distinguish ourselves from perhaps some other countries where that's not always the case. So it was initially aimed at the public sector. It's now been broadened more to include the private sector, and that means that all companies have some responsibility and some obligations around a process. They're not obliged to have a process documented, but we recommend that our clients do consider having that process documented, because it's something that people may not be aware of, and then by the time an issue arises, if there's not a process in place, then the horse might have bolted. And I mean, one extreme example probably is going to the UK is the Jimmy Savile situation in the BBC, where apparently it was well known, some of his criminal behaviour, but people weren't aware of a process to report that. So subsequently, the BBC contacted thousands of employees, and they said, yes, we knew there was an issue, but we didn't know who we could talk to or if we'd be taken seriously. So that's quite an extreme example, but that's the purpose of it.
So also, though, under the new law, doesn't it say that employees can go outside the organisation to report? Why then does the business need a process?
Yes, great point. So previously, the legislation required the person to go through their internal processes, and that was viewed as problematic to some extent, especially where perhaps they were identifying senior management behaviour that was unsavoury or illegal, and those were the people that were getting the information and being expected to deal with it. So now people can go directly to outside organisations, and those are specified in the statute. So there is the police, there's the ombudsman, and relevant authorities which can be contacted directly. So for many people, there is a fear if they raise an issue within the workplace, that they will suffer the consequences. And unfortunately, there's quite a few examples where that has happened.
Absolutely. Just finally, so what's the top line message to employers about this new whistleblowing amendment?
Yeah. Whilst you might not be bound to have a policy, we recommend that you do have a policy and you communicate this policy to staff, because we all want ethical practices in our business and in New Zealand, and this is one way to encourage at least a reporting of unethical or believed suspected unethical behaviour. So try to get a policy in there. It's not too hard to include, and have a process and make sure that staff are protected when they do raise these issues.